Dear friends, I, Ratnabali give a dictation for 120 words per minute. 5 seconds left. Start. Judicial review is the power of the judiciary to review the laws made and executed by the legislature and executive to make sure they are in line with constitution and the status enacted. If they contravene and provision, the judiciary strikes them down. Judicial activism is phenomena wherein the judiciary assumes an extraordinary position of directing the executive to undertake such policies and measures as the judiciary deem fit, citing insufficient policies of administrative lacuna. When judiciary in exercise of its judicial activism encroaches the domain of the executive and legislature, it is called judicial overreach. Although the proceedings in Supreme Court arise out of the judgments or orders made by the subordinate courts, including the high courts, but of late the Supreme Court has started entertaining matters in which interest of the public at large is involved, and the court can be moved by any individual or group of persons either by filing a writ petition at the filing counter of the court or by addressing a letter to Honorable the Chief Justice of India, highlighting the question of public importance for invoking this jurisdiction. Such concept is popularly known as public interest litigation, and several matters of the public importance have become landmark cases. This concept is unique to the Supreme Court of India only, and perhaps no other court in the world has been exercising this extraordinary jurisdiction. The concept of PIL emerged for the first time in the Mumbai Kamgar SABHA case, where Justice Krishna Iyer allowed the petition even if the litigant had no locus standi in the case. Justice Bhagwati later gives much momentum to the PIL movement. A writ petition in the form of PIL filed at the filing counter is dealt with like any other writ petition and processed as such. In case of a letter addressed to the Honorable Chief Justice of India, the same is dealt with in accordance with the guidelines framed for the purpose. After some of the courts overturned state laws redistributing the former zamindar estates on the grounds that the laws violated the fundamental rights, the Parliament of India passed the First Amendment to the Constitution in 1951, followed by the Fourth Amendment in 1955 to protect its authority to implement and redistribution. The Supreme Court countered these amendments in 1967 when it ruled in Golaknath versus State of Punjab that Parliament did not have the power to abrogate fundamental rights, including the provisions on private property. Similarly, other laws were declared null and void. They include on 1st February 1970, the Supreme Court invalidated the government-sponsored bank nationalization bill that had been passed by Parliament in August 1969. The Supreme Court also rejected as the constitutional a presidential order of 7th September 1970 that abolished the titles, privileges and privy purses of the former rulers of Indian old princely state. Stop.